Today I'm going to talk to you about first-degree murder. That's right, that's the big boy. That is the most serious murder charge someone can be accused of. And here in Minnesota, that means life without parole if you're convicted. You're never getting out of prison if you are convicted of a first-degree murder, unless, of course, you won on appeal or something like that. Other states will have the death penalty for first-degree murder, but in Minnesota, it is life without the possibility of parole. And what that means, this idea of premeditation, is some sort of thought going into the killing before actually doing it. So I'm going to read you a little bit of the law. To consider, plan, or prepare for, or determine to commit the murder. It involves what's called a cool mind that is capable of reflection for some kind of period of time before killing. But here's the thing. I think classically when people think about a first-degree murder, they think about what they see on TV, and that is someone that's taking a lot of steps to prepare for murder. Maybe they're thinking about doing it for days or weeks or months, and they're going out to stores and they're gathering the tools, or they're hiring a hitman to do it or something like that. While that certainly can be evidence of a first-degree murder, the law doesn't require it to be that long of planning. The courts, unfortunately, in Minnesota have been inconsistent with how they describe this premeditation or how long this premeditation has to last. It just says by definition it requires some amount of time to pass between the formation of the intent and carrying out of the act. But it can't be instantaneous or split second. It's got to be more than that. It doesn't have to be extensive planning, but some time has to pass between the intent to kill and the actual planning or preparation or determination that goes into that act of killing. So this is weird because even the term appreciable time is not defined under the law. It still can't be simultaneous with the intent to kill. There has to be some sort of time frame in between those. So extensive planning or calculated deliberation is not required, but there has to be some sort of pre-existing reflection and deliberation more than just the intent to kill, okay? So what does that all mean in English, right? Let me give you some examples. Most of the time in a murder case in Minnesota, it's going to be charged out, if the prosecutors believe it's intentional, they'll charge second-degree intentional murder. And that isn't a lot different than a first-degree murder, except that in a first-degree murder, the element of premeditation also has to be proven beyond a reasonable doubt. So the law prefers that if a murder is going to be charged, it be charged out as a second-degree intentional, unless and until the government can prove beyond a reasonable doubt that there's some element of premeditation or this sort of planning, contemplation, cool mind before doing it. So you and I get in a fight, and all of a sudden I pull out a gun. We're not dealing with guns at all, and I'm angry and I pull out a gun quick and I shoot you. Probably not premeditation in my view in that particular instance. But if I'm calculating about doing it and I'm thinking about it for a little while before I do it, that could be, in some circumstances, premeditation. There are some other factors the courts will look at. They'll look at, was there a previous relationship between the defendant and the alleged victim? Was there some sort of MO, desire, or motive for the defendant to be killing the alleged victim in that situation? Were there other steps taken to acquire a weapon, prepare a weapon, do any sorts of things like those? If it's a shooting, how many times were they shot? Was it in defense of others? Was it in self-defense? How much time went on between the grabbing of the firearm and the shooting? These are just some examples, for example, of premeditation. It doesn't just require a gun, but I'm trying to give you some examples. But there are sometimes temptations for the prosecution to overreach and go get an indictment, which is a grand jury indictment, or a charge of a first-degree murder, while there really wasn't extensive planning on the defendant's part, but rather was a quick reaction in that situation. In those instances, in my opinion, it wouldn't be proper to charge or certainly convict someone for premeditation in that instance, of course. But sometimes if a defendant doesn't plead guilty or take an offer, even on a second-degree murder, the prosecutors may sometimes, even out of spite, seek to go get a first-degree indictment, and a grand jury returns the indictment, not the prosecutors. But there's an old saying, of course, and that is that a prosecutor can indict a ham sandwich if they want. It's not particularly challenging to get an indictment because in grand juries, which is a topic of another video, the prosecutors get to secretly meet with the grand jury. A defense lawyer isn't allowed to even be there or know that it's happening, nor is the defendant, nor are any of the defense witnesses. So it's all a one-sided story based on who the prosecutor decides to bring before the grand jury to testify, and that's why the old saying is you can indict a ham sandwich. But that's just a little bit of a series on premeditated murder and the definition of premeditation in Minnesota. I'll make more videos that go a little further into first-degree murder and the other murder statutes here coming up. Do me a favor, if you like the video, let me know. Subscribe to the channel, hit a like button, send me a comment, do whatever you can. I like educating people about criminal law here in Minnesota and across the nation. I'm criminal defense attorney Ryan Pacyga. You can find me at arrestedmn.com or call me at 612-339-5844. Take care.